The East African Court of Justice, EACJ, is the judicial arm of the community established under Article 9 of the Treaty for the Establishment of the East African Community, comprising of 6 member states, namely Burundi, Kenya, Rwanda, South Sudan, United Republic of Tanzania, and Uganda. EACJ is mandated to ensure the adherence to law in the interpretation and application of and compliance with community laws as stipulated under Article 23, Section 1 of the treaty.
Since 2001, November, up to now, November 2021, it will be 20 years in existence. So we thought, even here from Arusha where we are, you can see that people are not aware of the court, of the jurisdiction of the court, of the business of the court, what the matters the court is dealing with. So if you go to South Sudan, people are not aware of the court. So if you go to Bujumbura, you find that people also are not aware. Even here, even in Nairobi, even from the original partner says. So we thought that with the 20 years of the court, it is better now we take the court closer to the people of East Africa. This is also for the visibility of the court, because the court is not an organ of the judges. The court is the organ of the community, and any judiciary is organized because of the people.
The role of this court is to listen to disputes between the citizens of the community and their governments. The role of this court is to solve and interpret the provisions of the treaty where partner states or where citizens of the partner states have a dispute concerning the interpretation and application of that treaty. The role of this court is also to look at disputes between the staff of the community and the employer. It's like a safety valve for the staff if they have disputes concerning any interpretation of their contract employment. This court also does arbitration matters. It has got jurisdiction on arbitration, and besides that, it also has mandate to carry out mediations between disputants who have come to the courts.
The East African Court of Justice, EACJ, is marking 20 years since its inception in 2001. When
I was appointed registrar, I just reported on duty to the Secretariat. At that time, the Secretariat was the one coordinating the entire community. It's very early, and the Secretariat, I think, was 1 year old or some few months old. So I reported to the Secretariat, and the Secretariat just showed me a small room with an old computer, and I was told, now get into this room, sit here, establish your court. So that's how I got started, and I had now to formulate everything from my architectural thinking, how the court should look like. And to start with, I started with the rules of procedure. Rules of procedure are very, very critical in any court. They provide the gateways, they show the entry points, they show you the doors, they show you the windows, they show you all matters and how to behave when you are inside the house. So I put in place formulate using some relationship, gathering experience from the European Court of Justice, which was our point of reference, and I put something in place so that when the judges were sworn in, immediately, the first thing they did, that very day, we adopted the rules of procedure. After adopting them, then we started modifying them, improving them, after doing some consultation with the stakeholders. And they have been going, I can say, reformation and blending and restructuring until they are now what you see them today to be.
Since the court's inception on 30th November 2001, the court has delivered a number of judgments which are a landmark.
The landmark case which actually shaped the court to be what it is today was the famous Professor Peter Nyang'anyong case. According to the treaty, members of EAR from each partner state are to be elected by the national assemblies. Now it was alleged, and it happened to be the fact that Kenya National Assembly, instead of electing, gave quotas, allocated a number of members of Iala just to represent. It was like Kanu, you bring it to Orange, bring it 3, instead of formally following the procedure of electing. In that case, a person aggrieved by that process challenged the procedure that led these guys to come to East African Legislative Assembly. And the court indeed was faced a testing moment. The court was requested to issue an injunction against these members from Kenya from being sworn in, pending a matter that had been filed in court challenging the process that led to their coming to Arusha, because it was assumed that they had issues back at home and they thought these judges from Kenya were carrying these issues, personal issues, with them to the East African community, and they took advantage of the position they were taking to punish or to revenge to their government, which indeed was not the case, unfortunately. But the judges were not cowed down. They were not intimidated. Indeed, the Iala was suspended for 6 months. And when the judgment was delivered by the court, it came out very, very clear that, please, Kenya, you go back and elect as the treaty provides, or else there is no Iala. And indeed, they had to go back and sit down to form, to reconcile themselves. Finally, they had to bring people who had gone through the channel as directed by the treaty. That is the spirit which had given this court name today.
We have been able to mediate one case which was filed by a non-governmental organization in South Sudan, and it was against the Attorney General of the Republic of South Sudan. After the pleadings had been filed, and there was also an application for a certificate of urgency, parties sought that to expedite resolution of that dispute, it would be good that we invoke the provisions of Rule 64 of the East African Court of Justice Rules of Procedure of 2019 to try and find out whether we could resolve it out of court. And I, being the presiding judge who presided over the scheduling conference, I attended the mediation session in Nairobi, and we were successful. We successfully settled that dispute, whereby parties agreed, and the matter was marked as settled.
Other landmark cases include:
the first case was this Karisti Andrew Mwatera was the first case, and actually it originated from Iala. The members of East African Legislative Assembly had filed a case against the Secretariat in the court and the Council of Ministers.
Another landmark case I could mention is the case of animal welfare against the government of Tanzania. Another major case I'll mention, landmark, is the case of BAT and Uganda. That is now one of the cases that is actually dealing with trade between partner states. Most of our cases, if you have noticed, have been dealing with human rights, which is not bad, because before you can even trade, you need to be sure of your human rights. Maybe another important case I would like to mention is the Media Council of Tanzania. The government of Tanzania enacted a law touching on media that was very, very, I could say, draconian. It had a lot of limitation for journalism. It had a lot of limitation on freedom of expression. The court ruled that that Media Act was against the provisions of the treaty and directed the government of Tanzania to go and amend their Media Act law to be in line with the provisions of the treaty.
James Katabazi and 21 others versus the Secretary General of the East African Community and the Attorney General of Uganda.
It was the first case that came to this court to say, to want this court to adjudicate on matters of human rights. The court ruled that what happened to James Katabazi was a violation of the treaty in itself. in as much as the court did not have direct jurisdiction on human rights, but it was a violation of the treaty. If you look at Article 6 and 7.2. Thereafter, that case opened a floodgate of so many cases of that nature that are now being filed in this court.
Appeal number 1 of 2017 arising from reference number 8 of 2015, Manario Desire versus the Attorney General of the Republic of Burundi.
Now that judgment, to me, it's a case that should be revisited. Marinayo was a Burundi citizen, but residing in US. Just because he was honest in his affidavit and says he's a resident of America, the court said he cannot bring a suit for whatever violation of the treaty in East African Court of Justice. Now look at it like this. The effect of that judgment is to discourage diaspora from investing. If I am living outside there, I am investing in East Africa, I am paying tax in East Africa, I have employed people in East Africa, then something happens to my investment. You are telling me I cannot file a case. So what are we doing? Are we encouraging investments? Are we encouraging diaspora to invest back home? No, that case is not. It is a case I wish somebody else will have a similar case. Maybe, probably, the bench might think otherwise.
Plaxida Rugumba versus the Attorney General of Rwanda. The Managing Director Mseto versus the Attorney General of the United Republic of Tanzania. Appeal number 2 of 2017, Right Honorable Margaret Ziwa versus the Secretary General of the East African Community.
One of the significance of Ziwa case is that you do not just do things without following the law. That is how Ziwa was removed from office, and the court found her removal from office was illegal. It did not follow procedure. Another thing that is of importance with that case is that after the court had said her removal was illegal and she suffered, she must be compensated. It is the first case of East African Court of Justice where damages were awarded. And after that, we saw others now following. We had another case from Burundi where also the winner was awarded damages. We had a case of a staff member of Eacj who was also awarded damages.
Eacj has made a number of achievements like opening up of sub-registries in East African Community Partner States, which will bring the court closer to the East Africans, development of the electronic filing system, scrapping of filing fees, thus making it free for residents who will access court without worry. Deployment of case management and recording system which enabled the court to work even during the COVID-19 pandemic.
The East African Court of Justice was the first of the regional courts and tribunals on the continent to go virtual. And when it went online, it went fully online. We conducted full trials with witnesses, with victims, with expert witnesses, and delivery of judgments.
Developed jurisprudence of the court.
You can see that the official policy of the community and of its partner states is to appreciate that a lot of their people are still rural, are still small, are still engaged in small enterprises, farming, business, and that they need assistance. So it is amazing when you can provide throughout all your other policies this level of understanding about where our people are coming from. And then when it comes to matters of them vindicating their rights, suddenly you say that a rural woman in northern parts of South Sudan, in the far west of Uganda, in the far east of Kenya, next to the Somalia border, in the far south of Tanzania, next to the Malawi border, should get themselves organized and come to court in Arusha in less than 2 months. It is just a complete contradiction. A year, in my view, would be more germane.
Increase in utilizing alternative dispute resolution mechanisms such as the mediation, arbitration, advisory, opinion.
And rules
Increased capacity building of the lawyers in the partner states on the rules of procedure which supports them to file cases and appearing before the Eacj. Eacj has had challenges. They include dwindling budgetary provisions.
I came in with the Secretary General. We adopted this teamwork spirit. we work together with the Secretary General, who is the executive officer of the community, so that at least the Secretary General understands the importance of the court as a judicial organ of the community. Because if the Secretary General understands that the court is a very important stakeholder of the community, then we will be also supportive to the court. But also, we decided to go together with the Secretary General around the partnerships, and we met the heads of state, the principal of the partnerships, the council, the minister responsible for EAC, who are the council members. I think to understand the business of the court and the importance of the court in the integration agenda. So I think now this issue of financial challenges, they will be resolved.
Ad hoc nature of the services of the court.
It has been difficult to deal with these matters as quickly as we would have liked to do. And this is a call to the heads of state and the Council of Ministers of the EAC to see that it is opportune now, it is a ripe time that the court should be fully functional and ensure that judges are made permanent.
Lack of financial and administrative autonomy of the court.
It is true that this court does not have financial administrative autonomy, but this one also has been already adopted by the Council of Ministers. So it has been adopted by the Council of Ministers. Now there is a bill. It is the private members bill from EALA, which has been adopted by the Council of Ministers. But it is now undergoing the comments from partners. Now they are commenting on that one, and we think the court cannot perform very well to its full satisfaction if it lacks the financial and administrative autonomy. That bill soon may be adopted, but also may be passed, so that at least this financial autonomy and the administrative autonomy of the court be granted to the court. And this is for the interest of the East Africans, but also for the interest of justice.
Despite the challenges, Eacj is also working with other organs to enhance their working relations.
East African Court of Justice, being one of the organs of the community, has demonstrated over the years its role and service to the citizens of East Africa. And indeed, we wish that this court continues to serve the people of East Africa as it is enshrined in the treaty establishing the community. We, as the other organs of the community, the Secretariat, we indeed continue to support the role of this important organ so that it continues to discharge its mandate to the people of East Africa.
We have a very good working relationship, and this has grown in the most recent days, and I think everyone has seen how closely we are working together. And we are doing that quite confidently and carefully because each of these organs has its own mandate, some of which are strictly independent. Our court is independent. Our legislative assembly has a degree of independence it should have to fulfill its own treaty mandate, and also the Secretariat. But we all understand that these organs of the community are meant to be complementary. Without stepping on or even infringing on each other's independence, we can still work together. I wish to see the court well facilitated. I want to see the court with the permanent judges, judges who don't come here on a part-time basis, but judges who are here on a full-time basis, because the trust that people have in the court is growing, and the work of the court will grow. And if we expand the jurisdiction of the court, then it won't be possible for us to continue working the way we are doing.
It has been, in my view, a good 20 years. I think in 20 years, the community has grown, the court has grown. We have grown also with the court and the community. The court has been courteous to all the parties before it. the partner states, the citizens, but it has also been quite competent and quite bold in trying to lay out the law as provided for by the treaty and by the general law of the community.
And even during this time of COVID, for example, we have seen the court readjust and even do some of their activities virtually. And that is to say, I congratulate them on their flexibility in terms of how they discharge their mandate. And therefore, all of us excited. We are all of us excited to see the court celebrate their 20 years.
I have seen the court grow and testify to the incredible achievement this organ of the community has achieved. It has made landmark decisions. It has created very significant jurisprudence. It has defined the law of the community in a way that continues to shape it and to give clarity and direction.
Therefore, we congratulate the leadership, we congratulate the court, we congratulate all the stakeholders who have really made use of this important organ and call upon all of us indeed to support this court, which is a very important organ of the East African community.
Now that I've been given this opportunity as the judge president of the court, it was a great pleasure to me to use now my experience in the court as a government lawyer, now as judge president, to take this court, the business of the court, closer to the people of East Africa and to people of the partner states. And then next year, this one will not stop. Now we'll be continuing on rotative manner. Next year maybe we'll be in Uganda, or in Kenya, or in South Sudan, or in Kigali. But now this process will not stop, because now we must take the court closer to the people of East Africa. We must take justice closer to the people of Africa. This is the intention.
Eacj at 20, upholding